Mr. Young, there have been 4 criminal charges filed against you in both of these cases. Have you received copies of those complaints?
Sir, I'm sure I have, but I haven't even read through them.
I want you to shut up, and I want you to answer my questions, okay?
I'm sorry.
My questions don't require an explanation. Yes or no? Have you received copies of the complaints?
Yes.
You have?
Yes, sir.
So I don't need to call the officer to make sure you receive them. Okay.
Yes.
So I'm going to read you your rights. One of those rights means you have a right to remain silent. So I'm going to enforce that right, even though I don't represent you. I'm going to ensure that you remain silent when you have to. So I'm going to read you your rights. So please pay attention to the rights I'm about to read to you. You do have a right to be informed of and to understand the nature and the elements of the charges filed against you. You also have a right to know the potential penalties that could be imposed. You are charged with 1 count of trespass in a habitation when a person is present or likely to be present. That is a 4th-degree felony. You are charged with 2 counts of domestic violence. The reason you have 2 counts filed against you is because there are alleged 2 separate victims. Also, domestic violence convictions are not sealable or expungible from your record. They remain with you for the rest of your life. You do qualify for court-appointed counsel, which I see here that you have submitted a financial disclosure form. If you do qualify for court-appointed counsel, there is a $25 application fee and a $100 cost reimbursement assessment that apply. Now, if you plead not guilty or enter no plea to these charges today, I will set your case for further proceedings after today, and I will set a bond.
Sir, I can do any of this. The only thing I did was walk up to my aunt's door.
Mr. Young, shut up. Shut up.
Why?
If you are not...
Sorry.
Mr. Young, be quiet, please.
I'm sorry, I forget.
So, Mr. Young, do you have any questions regarding the rights or the plea options that I just explained to you? You'll have to speak.
No, sir, I
Okay.
plead not guilty.
Okay, so are you saying you'd like to plead not guilty to all of these charges?
Yes, sir.
Okay. Now I'm going to address the issue of bond. The law director has submitted bond recommendations in each of these cases. The prosecutor is asking the bond be set in the amount of $25,000, cash surety 10%. The allegations are that on June 6, 2025, the defendant trespassed in the home of his aunt Lisa Pixley and Uncle Robert Pixley while Mrs. Pixley was present, asking that the defendant have no contact with Lisa Pixley and to remain off the premises. The prosecutor also indicates in that recommendation the defendant is homeless and presents a flight risk. In case number 25 CRA 179, prosecutors asking me to set bond in the amount of $100,000, cash surety 10%. The allegations are that on June 1st, 2025, the defendant assaulted his aunt Lisa Pixley and Uncle Robert Pixley. The defendant has 2 or more prior domestic violence convictions. You also have other pending charges in other courts, is that correct?
Sir, I feel like I'm getting bullied, man. I didn't do, never mind, but I didn't do none of this. And it's really...
Do you have other pending charges in other courts?
Yeah, I do, but
Okay.
just for probation and not seeing them.
Court does find Mr. Young has an extensive criminal history, having spent time in prison on at least 2 occasions. I will adopt the bond recommendations in 25 CRA 186. Bond is set in the amount of $25,000, cash surety 10%. In case number 25 CRA 179, bond is set in the amount of $50,000, cash surety 10%. Same conditions, not to consume or possess alcohol or drugs, subject to random chemical testing by probation and law enforcement, no contact with Lisa and Robert Pixley, and remain off the premises of 5156 Root Road in Monroe Township. Both of these cases will be set for a preliminary hearing in the very near future. Do you have any questions, Mr. Young?
No, sir.
Okay, thank you very much. This matter is concluded then.